The mode of appointment of arbitrator may not always work very smoothly in actual practice, but this may provide further opportunities for the organizations like Indian Council of Arbitration, International Center of Alternative Dispute Resolution, etc. Under the Act, an arbitrator, before accepting his appointment, is required to disclose to the parties in writing about such matters, which may create doubts about his impartiality or independence. Where such doubt exists, his appointment can be challenged. Similarly, where the arbitrator does not possess the required or the agreed qualification for the appointment, his appointment can be challenged as per section 12 and 13 of the Act. Grounds for challenge. The appointment of arbitrators made under section 11 of the Act can be challenged on the grounds as specified in section 12 of the Act. For that purpose, section 13 contains the procedure. According to section 12 of the Act, when a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances likely to give rise to justifiable doubts as to his independence or impartiality. Moreover, an arbitrator, from the time of his appointment and throughout the arbitral proceedings, shall, without delay, disclose to the parties in writing any circumstances referred to above unless they have already been informed to them by him. An arbitrator may be challenged by a party only if 1. Circumstances exist that give rise to justifiable doubts as to his independence or impartiality, or he does not possess the qualifications agreed to by the parties. Subsection 4 of section 12 makes it clear that a challenge is also permitted if a party becomes aware of these grounds after an appointment is made. Challenge procedure. Section 12 of the Act contains detailed provisions regarding challenge procedure. Subsection 1 provides that, subject to provisions of subsection 4, the parties are free to agree on a procedure for challenging an arbitrator. Subsection 4 states that if a challenge under any procedure agreed upon by the parties or under the procedure under subsection 2 is not successful, the arbitral tribunal shall continue the arbitral proceedings and make an arbitral award. But at that stage, the challenging party has the right to make an application in the court to set aside the award in accordance with section 34 of the Act. Subsection 2 provides that, failing any agreement referred to in subsection 1 of section 13, a party who intends to challenge an arbitrator shall, within 15 days after becoming aware of the constitution of the arbitral tribunal or after becoming aware of any circumstances referred to in subsection 3 or section 12, send a written statement of the reasons for the challenge of the arbitral tribunal. The tribunal shall decide on the challenge unless the arbitrator challenged under subsection 2 withdraws from his office or the other party agrees to the challenge. It is also provided that where an award is set aside on an application made under subsection 5 of section 13 of the Act, the court may decide as to whether the arbitrator who is challenged is entitled to any fees. Failure or impossibility to act as an arbitrator. As per section 14 clause 1, the mandate of an arbitrator shall terminate if he becomes de jure or de facto unable to perform his functions or fails to act without undue delay due to some other reasons. Mandate is also terminated if he withdraws from his office or the parties agree to the termination of his mandate. Further, if there is a controversy about an arbitrator's inability to function or occurrence of undue delay, a party may seek intervention of the court under section 14 subsection 2. However, withdrawal by arbitrator on his own or by agreement between the parties does not constitute acceptance of the ground of challenge. It is considered that the procedure for challenge to the appointment of an arbitrator need not be a matter of agreement by parties. The procedure in accordance with section 13 should apply in all cases. Substitution of arbitrator. In addition to the circumstances referred to in section 13 or section 14 of the mandate of an arbitrator shall terminate where he withdraws from office for any reasons or by or pursuant to agreement of the parties, where the mandate of an arbitrator terminates, a substitute arbitrator shall be appointed according to the rules that were applicable to such appointment being replaced. Unless otherwise agreed by the parties, where an arbitrator is replaced under subsection 2 and any hearings previously held may be repeated at the discretion of the arbitral tribunal. Unless otherwise agreed by the parties, an order or ruling the arbitral tribunal made prior to the replacement of an arbitrator under this section shall not be invalid solely because there has been a change in the composition of the arbitral tribunal. Section 15. Discuss the competence of arbitral tribunal to decide matters that come within the scope and ambit of arbitration. It's a problem. An arbitrator is a private judge of the parties and has a quasi-judicial status. The decision of an arbitrator has to be a judicial decision to be reached after hearing the parties and considering the evidence brought before him. The arbitrator is bound to observe the rules of natural justice to give a fair opportunity to the parties to be heard and decide the disputes in an honest manner. Section 16 of the Act empowers the arbitral tribunal to rule on its own jurisdiction, thereby providing tremendous autonomy to the tribunal. Thus, the arbitral tribunal can overrule any objection to the existence or validity of an arbitration agreement. The arbitration agreement gives jurisdiction to the arbitrator, and this jurisdiction is not relevant to the acceptance or denial of the agreement. The arbitrator decides his jurisdiction in terms of the agreement. The aggrieved party could apply to the court for a decision on the existence or otherwise of an arbitration agreement. Subsection 1 of section 16 envisages a ruling by the arbitral tribunal itself on its jurisdiction. The arbitral tribunal is also empowered to give ruling on any objections raised about the existence or otherwise and validity of the arbitration agreement, and for giving such ruling, an arbitration clause forming the part of the contract shall be treated as an agreement independent of other terms of contract. The subsection also envisages that a decision by the arbitral tribunal about the contract being null and void shall not entail ipso jure, that is, by the law itself, the invalidity of the arbitration clause. Section 16 also contains in its ambit pleas of non-jurisdiction or excess of authority. Subsection 2 of section 16 provides that a plea can be raised not later than the submission of the statement of defense where the arbitral tribunal does not have jurisdiction. It is further provided that a party shall not be precluded from raising such a plea merely because he has appointment or participated in the appointment of an arbitrator. Likewise, subsection 3 of section 16 provides that a plea that the arbitral tribunal is exceeding the scope of its authority could be raised by the party during the arbitral proceedings if the matter alleged is beyond the scope of its authority. Subsection 4 of section 16 gives discretionary power to arbitral tribunal to admit a later plea. It provides that the tribunal may, in either of the cases referred to in subsection 2 or subsection 3, admit a later plea if it considers the delay justified. The arbitral tribunal shall decide on a plea The arbitral tribunals shall decide on a plea referred to in subsection 2 or subsection 3, and where the tribunal takes a decision rejecting the plea, it shall continue with the arbitral proceedings and make an arbitral award. Section 16 clause 5 subsection 5. An application for setting aside the award may be made in the court by a party aggrieved by such an arbitral award. The application should be made in accordance with section 34 of the Act. Arbitration is an alternate form of resolution of disputes arising between the parties, and hence the arbitrator must have the power to decide all the disputes or differences arising between the parties. If the arbitrator has no power to award interest pendentility to the party claiming it, would have to approach the court for that purpose, even though he may have obtained satisfaction with respect of other claims from the arbitrator. This would lead to multiplicity of proceedings. Over the years, the English and Indian courts have acted on the assumption that where the agreement does not prohibit payment of interest and the party to the reference makes a claim of interest, the arbitrator must have the power to award interest pendentility. Interest pendentility or pendentilite is not a matter of substantive law, like interest for the period anterior to reference. For doing complete justice to the parties, such power has always been inferred and in fact a matter within his discretion, to be exercised in the light of all the facts and circumstances of the case and keeping the ends of justice in view. Next problem, discuss the commencement and conduct of arbitral proceedings. In domestic arbitration, the place of arbitration does not pose any problem. It can be anywhere in India according to the agreement of the parties. If arbitration is under the rules of an institution, it is generally conducted at the place where the institution is located, subject to agreement to the contrary. In international arbitrations, parties generally specify the place of arbitration in their arbitration agreement. If it is not so specified, Indian parties usually make use of, as far as possible, a joint arbitration clause which deals inter alia with the determination of the place of arbitration. In arbitration service agreements concluded by arbitral institutions in different countries, the place of arbitration usually specified is the country where the respondents reside. Section 20, Clause 1. Section 20, subsection 1 of the Act gives freedom to the parties to agree on the place of arbitration. Failing any such agreement, the place of arbitration will be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. Section 20, subsection 2. The arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation among its members, for hearing witness, experts or parties, or for inspection of documents, goods or other property. Section 20, subsection 3. The old Act did not explain in clear terms the point of commencement of arbitration. This difficulty is removed by Section 21 of the new Act, stating that the arbitral proceedings commence on the date on which the respondent receives a request for that dispute to be referred to arbitration. No time limit has been prescribed under the Act. However, where the arbitrator is guilty of undue delay, his proceeding can be put to a stop as per Section 14, subsection 1 of the Act. Language of arbitration. Section 22 gives freedom to parties to agree upon the language or languages to be used in the arbitral proceedings. The arbitral tribunal, subject to agreement of parties, has power to determine the language or languages to be used in the arbitral proceedings. Generally, the language of arbitration is English. It being the international language, the parties and the arbitral tribunal agree the same in most of the arbitration. The arbitral tribunal may ask for translation of documentary evidence into the languages agreed upon by the parties or determined by the arbitral tribunal. Arbitration procedure. The Arbitration Act 1940 did not have any detailed rules as to pleading, etc. And after the arbitrator's appointment, the parties exchanged pleadings, claims, counterclaims, rejoinders, and documents, etc. in accordance with the directions of the arbitrator. Section 23 to 27 stipulate the procedure to be followed in arbitration proceedings. Under the old law, the practice adopted by the arbitrator regulated the different stages of arbitration. The new law gives a comprehensive guidance regarding the procedure, such as filing of a claim, submission of difference, amendment of claim, difference, etc. Section 23 and 24 of the Act sets out the stages of arbitration proceedings in an orderly manner. Section 23 of the 1996 Act makes provision as to statements of claims and defense. Section 23 subsection 1 provides that within the period of time agreed upon by the parties or determined by the arbitral tribunal, the claimant shall state the facts supporting his claim points at issue and relief sought. The respondent must then state his defense. Section 23 subsection 2 provides that the parties may submit with their statements all documents they consider to be relevant, or may add a reference to the documents or other evidence they will submit. Subsection 23 subsection 3 further provides that unless otherwise agreed by the parties, either party may amend or supplement the claim or defense during the course of the arbitral proceedings, but the arbitral tribunal may disallow the prayer for amendment on the ground of delay. Section 24 subsection 1 of the 1996 Act provides for hearings and written proceedings before the arbitral tribunal. The arbitral tribunal shall decide, unless otherwise agreed by the parties, whether to hold oral presentation of evidence or for oral arguments, or whether the proceedings shall be conducted on the basis of documents and other materials, etc. Subsection 2 of Section 24 requires that the parties shall be given sufficient advance notice of any hearing of any meeting of the arbitral tribunal for the purpose of inspection of documents, goods and other property. Further, Section 24 provides that all documents of statements, other information received from one party must be communicated to the other party. Determination of rules of arbitral procedure. Section 19 follows the two-level system. It grants the parties freedom to determine the procedural rules subject, however, to certain mandatory rules. Subsection 1 envisages the non-applicability of the Code of Civil Procedure 1908 and the Indian Evidence Act 1872. This position is not different from the position obtaining under the Arbitration Act 1940. The arbitral tribunal is, however, bound by the rules and principles of natural justice, requiring right of cross-examination and of hearing one party in the presence of the other party to facilitate the cross-examination. The non-applicability of these two acts frees the arbitral tribunal. What are the two acts? The arbitral tribunal is, however, bound by the rules and principles of natural justice, requiring right of cross-examination and of hearing one party in the presence of the other party to facilitate the cross-examination. Following the rules of natural justice and hearing one party in the presence of the other party. The non-applicability of these two acts frees the arbitral tribunal from the fetters of adjective law and procedural rules, but not from the observance of fundamental principles of natural justice, example, giving of adequate opportunity to both the parties. In terms of subsection 2, the parties have the freedom to agree on the procedure that may be followed by the arbitral tribunal for conducting the arbitral proceedings, subject, however, to the condition that the procedure is not contrary to the provisions of Part 1. Section 19, subsection 2 provides a default alternative procedure if the parties fail to specifically agree upon them. In the event of there being no agreement between the parties as to the procedure to be followed, the arbitral tribunal may follow the procedure it thinks appropriate and may conduct the proceedings accordingly. The recourse taken to by the arbitral tribunal regarding the adoption of procedure should be in accord with the provisions of Part 1, that is, in accord with the provisions of Section 23 to 25. Though the technicalities of the Indian Evidence Act are not applicable to the arbitration proceedings, subsection 4 empowers the tribunal to determine the admissibility, relevance, materiality, and weight of any evidence. This section recognizes the freedom of the parties to lay down as to how to conduct the proceedings subject to agreement of the parties. Freedom to lay down rules of procedure is subject to following restriction mandatory provision laid down by law. Submission of a statement of a claim and defense under Section 23, The parties should be given sufficient advance notice of any hearing and of any meeting of the arbitral tribunal for purposes of inspection of documents, goods, or other property under section 24 subsection 2. All statements, documents, or other information supplied to or application made to the arbitral tribunal by one party should be communicated to the other party, and any expert report or evidentiary document on which arbitral tribunal may rely in making its decision should be communicated to the parties. Section 24 subsection 3. The arbitral tribunal or a party with the approval of the arbitral tribunal is allowed to request the court in taking evidence under section 27. An award in agreed terms must state that it is an award and should be in accordance with section 30. An arbitral award must be in writing, signed by the majority of all the members of the arbitral tribunal as per section 31 subsection 1. The arbitral award must state its date and place of arbitration under section 31 subsection 4. A copy of the award duly signed by the arbitral tribunal should be delivered to each party under section 31 subsection 5. The arbitral proceedings are terminated by the final arbitral award or by an order of the arbitral award under section 32 subsection 2. The arbitral tribunal has power to correct any computation errors, any clerical or typographical errors under section 33. Judges are bound by the Code of Civil Procedure and also by the rules of the court while conducting proceedings in the court. There is no corresponding arbitration procedure and rules. Permanent arbitral institutions have their own set of arbitration rules, but those rules do not regulate the procedure in detail. The arbitral tribunal is master of the procedure of arbitration, subject, of course, to restrictions imposed by law, agreement of parties, and natural matter for a quick and cheap resolution of disputes. Power to terminate or continue the proceedings. Section 25 of the Act provides that subject to agreement between the parties where, without showing sufficient cause, the claimant fails to communicate his statement of claim within the agreed period, the arbitrator shall terminate the arbitral proceedings. Similarly, where the respondent fails to communicate his statement of defense within the predetermined period, the arbitrator shall continue the proceedings without treating such failure in itself as an admission of the claimant's allegation. Further, when a party fails to appear at an oral hearing or to produce documentary evidence in support of its averment, the arbitrator can proceed and pronounce the award on the basis of evidence available before it. Appointment of experts by arbitral tribunal. This act grants the power to an arbitral tribunal, failing agreement by the parties to the contrary, to appoint one or more experts to report to it on specific issues to be determined by the arbitral tribunal. I'll read that again. Appointment of experts by arbitral tribunal. This act grants the power to an arbitral tribunal, failing agreements by the parties to the contrary, to appoint one or more experts to report to it on specific issues to be determined by the arbitral tribunal. It also requires a party to give the expert any relevant information or to produce or to provide access to any relevant documents, goods, or other property for his inspection. Since the provision is not non-mandatory, the parties may exclude such power. In such situation, the arbitral tribunal will have to decide the dispute without obtaining necessary expertise, which it itself lacks. Likewise, in the absence of an agreement by the parties to the contrary, if the tribunal considers necessary on the request of a party, the expert, after delivery of his written or oral report, shall participate in oral hearing, and parties will have the opportunity to question him for testifying the report of the expert on the points at issue. The parties will have the right to produce their own witnesses. Furthermore, in the absence of a contract to the contrary, On the request of a party, the expert is required to make available to that party all documents, goods, or other property in his possession which were given to him in order to prepare his report. Court assistance. Section 27 refers to the court's assistance in taking evidence. It provides that the arbitral tribunal can take assistance of the court in securing the attendance of witnesses or for the production of documents. The arbitral tribunal can also make the application with the court specifying details for securing the attendance of witness or production of documents. The court may issue processes to the witnesses in the same manner as if the suit is being tried by it, directing the witnesses to provide the evidence directly to the tribunal. In addition to it, the parties to the dispute may also approach the court with permission of tribunal for the same purpose. The court may also issue summons to the commission for examination of witness and for production of documents.